Ladies and gentlemen, it gives me great pleasure to welcome you all to the final hearing in this, the 25th annual Willem C.Vis International Commercial Arbitration Moot. Today, we have a hearing between the University of Cambridge as claimant and the National Research University Higher School of Economics, Moscow, as respondent.
My name is Willem. I'm a partner at German & Sterling, based in Paris.
My name is George Berman, professor at Columbia Law School and director of its Center.
I am professor of private international law at the University of Mainz and been associated with the MOOC now for.
My name is Gaina Gulan. I will present respondent's position on procedure, and my co-counsel, Mr. Vladimir Kosta, will present respondent on merits. Arbitration is rested in confidence and trust, vested by the parties in their arbitral tribunal. However, in the present case, respondents' trust in the integrity of the current proceedings has been undermined due to the connections existing between claimant's appointee arbitrator, Mr. Prasad, and claimant's third-party funder.
Portions of the record, it seemed to me that what you had agreed on was ad hoc arbitration only, and you had not agreed on anything more than that. Can you tell me why I should understand the arbitration agreement differently?
Parties in the present arbitration will reach a consensus, which means that under the circumstances of the present case, and in line with Article 6 of the Ancestral Arbitration Rules,
with a challenge and an appointment.
No, Mr. Arbitrator, there will be also a threat, because as follows from official website of the Permanent Court of Arbitration, the standard for challenges is justifiable doubts. However, as the Ancestral Arbitration Rules themselves do not further elaborate on this standard,
See the different entities that fund sets up for each fundings, because I take it that it was not the same entity that is funding the client in this
To the funding feature having emerged. And that disclosure, correct me if I'm wrong,
but the firm we are contesting here is the new one, the merged one, Prasad and Slow Food.
does that make a difference?
Yes, because there is no advance waiver.
Members of the tribunal, as I've said, my name is Barnaby Lowe. I'm representing the claimant, and I will be speaking on the procedural issues, which, in short, we regard as nothing more than an attempt by the respondent to delay paying our client for goods which the respondent ordered, the respondent took delivery of, the respondent disposed of. As I say, opposing counsel relied on the parties' intentions behind this clause and relied on a witness statement of one of opposing counsel's clients.
The dispute resolution clause encompasses the issue at stake here at this moment, involvement.
General agreement regarding Article 13.2 that, and I'm quoting, the decision is entrusted to all members of the tribunal, including the challenged arbitrator.
Actually, the UNCITRAL rules, namely 13 and 17 of the UNCITRAL rules.
Clause 20, subsection A of the parties' agreement provides that the tribunal must be composed of 3 arbitrators.
I agree that if a party to the proceeding is unable to have a party appointed,
Challenged if, during the course of an arbitration, including on procedural decisions,
Members of the tribunal, respondent will raise 3 grounds on rebuttal. First,
thank you, members of the tribunal. Opposing counsel made 3 points of rebuttal, and I shall deal with each of those. Firstly, opposing counsel said that an appointing authority should be excluded because the parties wanted to exclude the risk.
Good afternoon, members of the tribunal. My name is Ian Cooper, and further to the introduction, I shall be addressing the 3rd and 4th issues under the first procedural order.
that demonstrates that the expectations upon which the parties agreed were best efforts only.
If that satisfies Mr. Arbitrator, might I continue?
Yes.
Thank you very much. So, to determine which party standard conditions govern this contract,
Now, how do you square that with a best efforts standard?
within the contract, however, it is our submission that when determining whether the goods are of the quantity, quality and
size. So what are we supposed to make of this in terms of the requirement of a clear communication?
Reading from the final paragraph, the final sentence of Mr. Tsai states, if you have any further questions...
In any language, is that. So how do you explain that?
The express derogation we submit is found on page 16. It is the footer which is clear.
The standard to be used. I won't use our time, which is precious, to go through all the indications we have
Other than an obligation of best efforts. And I would remind the tribunal that it was on the basis of this assessment.
Madam Presiding Arbitrator, members of this tribunal, my name is Vladimir Kostov, as previously introduced, and in the following 14 minutes I will present the respondent's position on the merits. This is even more so that the sales offer itself, as previously discussed, and the most prominent example is page 8 of the record, that it is very...
Mr. Kostov, I have a question regarding C5, if you can take it, please. It's a letter from Ms. Ming to the claimant, referring to such commitment, I quote, is well evidenced in your...
Appropriate standard under the CISG is not just awareness of the contents of standard conditions, but in fact awareness of the intention to make...
Just wondering about the point I was raised to the opposing side. There was, after all, a slight reference by the claimant to the respondent in that letter where they said, well, primarily it's two changes.
I can direct your attention to page 15, to what appears to be the transmittal letter.
Here claimant states, thank you for your information concerning the arbitration clause contained in the invitation to participate in the tender process. This was done in the context of a commercial discussion, and of course physically one can never guarantee that a contractual breach will not occur, but one can accept the risk. Article 35 of the CISG particularly is clear. It is always an obligation of result. Of liability. And if, for instance, now we decide that claimant only uses best efforts, this will essentially mean that respondent is left without a remedy, and claimant will not...
In rebuttal, I make 4 points. The first is that opposing counsel took the tribunal through a chronology of events.
I will address the 4 points raised by the opposing party in turn. First, in relation to, again, the letter of Mr. Tsai on page 15, where he allegedly expressed a clear intention to incorporate...
Much for a wonderful presentation.